Jay Sheryll here. I'm going live to you today from my office. I had a 2:30 scheduled and that canceled. So I have a last minute few spots open here that I wanted to make open to everybody to talk about some estate planning. And so I wanted this to be an open Q&A. Anybody can pop on here and ask a question. I'd be glad to answer it for you. As it relates to estate planning. Many of you know me. I only do estate planning here at Sheryll Law. We do estate planning, probate, elder law. So don't ask me anything about a personal injury action or a DWI or a ticket or anything like that, because I will tell you, I do not know. That is not the area of expertise that we have. So I stick to my lane, estate planning. So, in today's day and age, that is a very, very important topic right now, given that we're in a state, we're in a global pandemic dealing with healthcare. Now, any questions that you do ask on here, I cannot, what I can't do is give any specific advice about you, legal advice, but I can answer general questions about estate planning, and so much of it's general. And the reason we do that is because I can't give legal advice, obviously, over Facebook Live, but also this is open to the public. So you can ask a question in the chat and just don't disclose any confidential information or anything like that. But what we see commonly people asking is, hey, I'm in the middle of this COVID pandemic, and what do I really need to have as part of my estate plan? What are the key components, and does it have to be complicated? So that's commonly a question that we receive, and the answer is it doesn't need to be complicated. There's some key documents you need that they take care of not only what happens to your money when you pass away, but also who can make healthcare decisions for you and who can take care of your personal and property needs during your lifetime if you were sick. That's probably a very overlooked area of estate planning that we see that becomes an issue. So most people know about a will, and what a will can do is when you pass away, a will allow you to pick both an executor and beneficiaries. Now, often they're the same people. What an executor does is, think of it like a captain. An executor is the person that is in charge of taking care of your assets when you pass away and giving it to your beneficiaries, right? So your beneficiaries are the people that you want to leave your money to when you pass away. So often the same people. For example, if I have children, I would leave my executor many times to be one of my children or multiples of my children, because they're the people that are getting my assets. If you don't have a will, what happens then? What happens is that the state has written a will for you. The state has a will that's what they call intestate succession. And what it says is that if you, for example, are married with children, the state says that the spouse has the first right to be what they call the administrator, the captain, right? The person who's in charge of taking care of the estate. And the beneficiaries, though, are different than what you might think. Without a will, if you're married and have children, the state has a will for you. And what it says is the surviving spouse gets the first $50,000 of the estate, and then they get the other half. Half of what's left, while the children get the other half. So let's take an example. If I have $150,000, the surviving spouse gets $50,000, and then there's $100,000 left. So $50,000 of it goes to the children, and $50,000 of it goes to the surviving spouse. Now, for many of our clients that we work with, I think for most people married with children, that's not what they want to have happen, right? So it's really important that they go ahead and prepare a will, because the state's quote unquote will is making that choice for you, and it's leaving everything to who? It's leaving everything to the surviving spouse and partially to the children. For example, a lot of times we deal with estate plans. People are older, right? And at the same time, we have many parents, younger parents, that are clients of ours, and our concerns are not about necessarily so much about the long-term care planning that we do for older clients, but if I have, for example, me, right? I have children. I don't want my 5-year-old and my 4-year-old. I mean, you've seen them here. Many of you know them, but that's everybody right there. That's Eliana and Lily and Brigitte. I want Brigitte to inherit. I don't want the kids to inherit, right? So if they inherited, it would kind of actually be a terrible thing, because what would happen is Brigitte would have to go to court to become the custodian over the money for the children. So half of my estate, instead of going to Brigitte, would end up in court and having to be part of this court proceeding where Brigitte would have to account to the court and ask for permission to spend money on behalf of the kids, which is crazy, right? Like, as a surviving spouse, if something happened to any one of us, right, we would want to make sure that the surviving parent has the ability to spend money on behalf of the children without having to go to court. I mean, that's crazy. So, that's one of the major things that we see with a will. So how do you change that? You don't, it doesn't have to be complicated. You put together a will. And the will, you would just have to say, like I've done, is to say, don't tell Brigitte, right? Now Brigitte knows. We'll have a will, and the will would say everything to my spouse. And that would take care of that. That would take care of making sure that these minor children that you may have, or children, or even for the older person, making sure that children aren't the beneficiaries. But this goes the same thing for both what I'm talking about here with minor children, because very important for them, but it also is equally important for maybe grandma and grandpa, mom and dad, right? Because what happens there is that surviving spouse, maybe the husband passes away, grandpa passes away, and now mom and her brothers and sisters inherit money instead of the money going to the surviving spouse, who's now left trying to figure out how to make ends meet. So, that is a really important part. Another piece of a plan with a will, for example, that many people don't think about is if you have minor children, you actually in your will can make a designation of a guardian. Okay, so this really comes up is if you were married and there's a joint car accident, let's say, and you and your wife, me and Brigitte, are killed in a car accident, or let's say not even killed. No one can have custody over our children and provide for them. We get to go ahead and say, look, we have a priority list of people that we want to serve as guardian for our children. Without that, what happens? I mean, picture it. Everybody has good intentions all the time. They'll have Eliana and Lily's best interests in mind, of course, but you'll have my parents and her parents trying to become, getting custody over the children, trying to become guardian. Maybe you throw in a couple of my brothers. I got 3 of them, so there's a couple more to the mix. And then Brigitte's got a sister. So throw all of that in there. It leaves kind of a mess because in the moment of stress, everybody's going to have the kid's best interest in mind, of course. But they're all usually going to have a pretty different opinion on what that best interest really means, right? So that is always a concern we have. So how do you get around that? In the will, what you can do is what you do in the will is what you do is you name a guardian, right? So that's another important piece of a will that people don't think about. If any of this stuff that you have questions about this, just throw it in the chat and I'll go ahead and answer the questions, obviously, for you. What else is an important part of an estate plan? So we talked about advance directives, right? And what is that? So that's your power of attorney, your healthcare proxy, living will, all really important things that need to be set up. This is now not taking care of when you pass away. This is taken care of during your lifetime. I've had scenarios with clients, and this could happen to any one of you, is that being married doesn't allow you to make, for example, financial decisions on behalf of your spouse. That you have to have a power of attorney for. So if Brigitte or myself were incapacitated, couldn't handle our finances anymore, I wouldn't be able to take care of her finance. I wouldn't be able to pay off her student loans. I wouldn't be able to collect disability for her if there was an issue. I wouldn't be able to collect mail for her. I wouldn't be able to open and close or pay credit cards, right? Banks that we don't have in our joint name would be frozen from me, the spouse, right? We don't really think about that stuff. What happens, just like with the will, if you don't address it, the court's got things figured out. As a spouse, you can go to court to become appointed the guardian for your spouse. But think about that. I mean, I'm married to my wife. She's married to me. And we have to go to court to get powers to be able to act on behalf of each other. And then on top of that, much like with the children, acting under a court supervised account, we have to account every year to the court. We have to ask for permission from the court to make certain expenditures. But it's not just free access to the money, which is what you would think would be the case, so that I could care for my my spouse, as I pledged that I would do when we got married, right? So that is another key component of estate plan. Same thing with a healthcare proxy, actually. So I can't make healthcare decisions for my spouse. What happens there is that only in a limited setting, in a skilled nursing facility, or rather a hospital, that I could make medical decisions for her. Outside of that, if I need to put her in a skilled nursing facility, put me into a skilled nursing facility, rehab, home, anything like that, we don't have these emergency medical powers. I would have to go to court to get power to be able to make medical decisions on behalf of my spouse. So that's something that we want to make sure we address. Obviously, anywhere we can plan to avoid the need to go to court, that's where we try to help people out. Because anywhere there's a court, you can think annoyance, time, and expense, right? And so those are all things that we are thinking about when we do an estate plan. Another key component of the estate plan is a living will. And a living will is basically a document that you can put together that says, look, if I'm in a coma, permanently vegetative state, I don't want to be kept alive artificially, right? That's not what I want. If I have no chance at recovery, pull the plugs, right? Pull the plugs. I want to give that power to my wife, right? To be able to make that decision, fight for me, because I don't personally want to be kept alive on machines. I don't want maybe her trying to pull the plugs because that's what I wanted, while my parents saying, well, no, we know he wouldn't have wanted that. That's where you make these wishes known beforehand, right? And so that is a key component of estate plan, a living will. Another piece of an estate plan would be a HIPAA appointment. So your healthcare agent really sometimes doesn't have access to your healthcare information. Go and figure why. Because sometimes you can see what's going on right now. The federal government and the state government are two different things, and sometimes they can get into a sword fight, right? Of who actually has the power, right? So the healthcare agent is something that's authorized by state law. So New York State is the one that tells you that you can authorize a healthcare agent to make medical decisions for you. But the federal government makes medical information confidential. So in most cases, it's not a big deal, right? The state will allow, the federal government will allow a healthcare agent to have access to medical information by us putting HIPAA provisions in, confidential provisions in, access to confidential information into the healthcare proxy. But the federal government goes a step further and allows the appointment of a HIPAA agent. And that's always something we recommend just in case, where we see something going on where the federal government turns around and says to doctors, no, you can't release information to a healthcare agent because the information is actually protected under HIPAA, okay, which is a federal regulation. A common question we always get, thanks, Karen. Thank you very much. At any time. I mean, I'd love to share this knowledge. I mean, it's things that people need to know. A lot of times we get a question about the living will, and it says, well, does that mean that if I sign a living will that I'm never going to be intubated? Does it mean that I'm never going to be resuscitated? And the answer is always no. The living will doesn't say that. The living will says that if you have no chance at recovery, only in that event, if you have no chance at recovery, then and only then does the living will take effect and say, then don't intubate me or withhold the intubation, right? Pull it. Don't resuscitate me if I have heart failure then in that state, right? So that is something that's very, very narrow. Now, the flip side of that coin is the question we get after that. Well, what if I want that? What if I have religious beliefs that I never want to be resuscitated? I never want to be on intubation, artificial nutrition. It's not what I want. That's not something that can be done as part of your estate plan, although a very, very important piece to address, because an attorney in New York cannot prepare the documents that would do that for you. The documents that would take care of saying, never intubate me, never resuscitate me, would be done in what's called a do not resuscitate, or commonly called a DNR. Or it could also be done in what's called a MOLST, and that goes a little step further. A MOLST is a medical order on life-sustaining treatment. And a MOLST, what that does is say, I don't ever want to have this treatment. You would have that done by a physician. A physician has to do that for you. So go to your general physician if that's the wishes that you have, and have those wishes completed. You can put them on file with your local hospital, so that way they know. Because this is not going to be something that can wait for your healthcare agent to come down and have a determination after a couple of weeks of treatment and find out that you're permanently vegetative and pull the plugs. If you don't want to be resuscitated, you need to have that DNR on you. They have bracelets you can get. They have medical ID cards that we can get for clients once we prepare these advanced directives. So that way you always have these things on you. Even a healthcare proxy have access to that medical information in the event of emergency if you're on vacation across the world, right? It's important to have that stuff readily accessible. And that's especially the case with the DNR and a MULS. So putting that on file can be very helpful. Some common things that we see happening that people have questions like, well, what are my options? Do I just need a will? And where does the trust fit into all this? Are those only for the rich and the famous, right? And the answer is no. I mean, a will is a really good option, and it's definitely a base level. So we kind of talked about the core documents, the foundation of an estate plan. But a trust can be a very, very important tool for many people. We often see trusts being used for people who want to protect assets, right? They want to protect assets for estate tax purposes. They want to protect assets from long-term care expenses like home health aides and nursing homes. They don't want the state to come in and quote unquote take their hard-earned assets. But another common place that we can see a trust being used is for the avoidance of probate. And so one of the common misconceptions that we see as estate planners is that people will say, I'm putting together a will, so that's going to make it so it's so easy for my kids. They're not going to have to go to court, and it's going to avoid probate. But that's not the case, right? That's a huge misconception. Every will needs to go through probate. When you pass away, what happens with your will is the person that you've named as your executor actually has to go to court and prove to the court that the will that they're offering, right? We call it probating, propounding. The will they're offering is actually your last will and testament. I mean, think about it. It makes sense when we talk about it. We call it our last will and testament, but a person may have multiple last will and testaments. They may have signed one when they graduated college. They may have signed one when they had their first child. They may have signed one when the kids went off to college. And they may have signed one when they come in to do estate planning for Medicaid planning and protection. All of these wills are valid wills, so that all these wills could be valid wills. What's going to happen is you're going to have to prove the validity of the last will, the quote unquote last will. And if that will is invalid, right, then what happens? It falls down to the next one. But there's this process, and there's specific requirements for the execution of a will. It's not really something that you could just do yourself. I mean, it has to be signed a very certain way. And the result of it's not done properly is that the will is actually invalid. And so that's what that process is for probate, is that the will has to be proven to be valid. And that takes getting witness testimony, that have the people who saw the person sign the will. It takes getting an attorney's affidavit, attorney's testimony, that all the statutory requirements were complied with for the creation of the will. This can be a process. Now, it doesn't necessarily need to be complicated, but it does take time. I mean, this is something that I would have never envisioned saying to you a year ago when I talked about probate, but during COVID, for example, the court was closed. The court was closed for almost 2 to 3 months, and then they were behind trying to get back to speed with processing these wills. And for all of those estates that had just wills and hadn't utilized the trust, what happened was they had to wait, maybe are still waiting in some cases, for the court to actually appoint the executor. And many people stop me right there and they say, well, Jay, hold up a second. I thought you said to me when I create a will, I get to name an executor. What you're actually really doing there is you're nominating an executor. And the court has to follow your list of nominations. But the court not only has to be satisfied and issue an order that that will is actually valid, they also have to qualify the executor. I mean, there's some specific requirements that an executor has to meet in order to qualify to be the executor. So for all of those clients, all of those people that may have passed away during that time where the court was closed, nobody could access their assets. No one could manage the real estate. No one could sell the real estate. No one could take care of the bank accounts that were in the person's sole name. There was no access. Think of everything kind of being frozen until the court acted. Meanwhile, what happened with people who had trusts, there's no need to prove that document, okay? There's no need to go to court to prove that document and have a trustee. There you truly are picking your trustee upon your death who can have immediate access and control. Now, that may not be the need for everybody, but where is that really important? I think it's really important, I see, with many people who have real estate, businesses, or minor children. Real estate, can we really wait 4 to 6, maybe 5, 4 to 6 weeks, maybe even 2 to 3 months in order for the court to appoint an executor? Maybe not. I don't know. I don't have a crystal ball. If I had a crystal ball, I'd be down in Key West right now because I would have gotten out down there before the quarantine hit, and I'd be sipping on margaritas. But I don't have that crystal ball. But we don't know what the future holds, right? So maybe it becomes really, really important to right now, for example, capitalize on a bubble in the market or even a dip to get out, right? That we want to have immediate access and immediate control over the asset. For example, with minor children, it can be really important. So for me, I've set our plan up with a trust because I don't want to have to wait for the executor to have to go to court to get access to our money for our minor children. We've picked a guardian, but that guardian is going to need money to be able to care for the children. I don't want to create a financial strain on the person right off the bat. I want to have immediate access available. Now, you might say, well, can't I just name the kids on an UTMA account, right, or a custodial account? But the problem with that is that they're underage, right? So if you have minor children, you really can't do that. You can, but it's going to go down that whole route again of having a custodian appointed or a guardian appointed and having under court supervision, which we don't want to have. I don't want to have my guardian having to go to court every time they want to get money and having to have the court taking a very, very conservative approach and saying that, look, our goal here is to protect this money so that way when they hit age 18, which is another problem, that they get all the money outright. I don't know that that's what many of our clients want, and it's certainly not what I would want. I would rather have my trustee, while they certainly have to act wisely and have a really, really significant responsibility there, but to have a more liberal construction to say, no, I want you to increase this child's quality of life, go ahead and pay for a camp and do all these fun things, dance class, and all these things that may not really be necessities that the court would determine, right? That may be things that I would have wanted to align for my children if I had been living. So that can be a very important piece. Another good place to have a trust is where you have real estate in multiple states. So maybe you have a home here on Long Island, maybe you have a vacation home in Maine, and maybe you have the winter escape and getaway down in Florida. Remember, we've said if we just have a will, it's going to get the basics done. It's going to get the job done, but it's got to go through probate. And remember what we said about probate. Probate will have to happen, and you have to prove that will's validity. Now, what happens is that actually has to get done in every single state that you have real estate. So not only do we have to do an idea, we have to do not only one probate proceeding, there we have to do 3 probate proceedings. So again, not the end of the world, but things that we can get creative with the estate plan to think outside the box to really give people peace of mind and knowing that it will be as easy as possible for their beneficiaries and things will operate as smoothly as possible. So that is really, really a key piece of an estate plan for many people. Now, that doesn't also mean that you have to then create a trust now. So what if, you said to me, well, I don't really want to create a trust now. Maybe you really don't have a lot. Maybe I just have life insurance. Maybe that's my major asset. Maybe I'm still paying off student loans. Maybe we just bought the house. So the house is, not a ton of equity there. We're still paying the bank a lot of money there. Really what I have is life insurance, and I already have it set up, Jay. I have my wife named as the primary beneficiary, and I have the kids named as successors. That is again, perfectly good thing to do. There's the problem, though, is with the minor children. The minor children become an issue because if I passed away and my wife passed away and I have a life insurance policy that has Eliana and Lily named as the beneficiaries, How old are they again? 5 and 4. Now, hopefully it won't happen this year, but if it happened next year, it'd be 6 and 5, right? They can't inherit that money. So what's going to have to happen? Someone's going to have to go to court to get access to those funds and put that into that custodial guardianship account where the money is going to be significantly limited. And the court's goal is to allow the money to stay there in that custodian account as long as possible and make it so that way when they turn age 18 that they will get all of that money, as much of that money as they can. So what becomes the problem there is, well, rather we talk about the problem, what's the solution? Is to set up a trust within your will. So there's really, people think of trusts, they're like irrevocable, revocable. That's not really, that's how it works. I mean, you have many different types of trusts, but really the two buckets that you can work into trusts are living trusts and what we call testamentary trusts. I'll call them dead trusts right now. A living trust is a trust that you create during your lifetime, kind of like the one I mentioned to avoid probate. I'm creating a trust, I'm putting things in it, I want to avoid probate, so I want to create this living trust, a trust that I've created during my lifetime. And that really, you need some assets to make sense for many people, right? Because otherwise you don't really get the benefit of the trust by not having assets. But you also have the option of within your will, creating what we call a testamentary trust or a dead trust. And it's basically saying, I'm creating a trust within my will. So saying, I'm going to have let's go to that same example of life insurance, right? I'm going to have my will. I'm going to say everything goes to my spouse. And then if she passed away before me or alongside me, that it goes to my 2 children. And if it goes to my 2 children, if they're under the age of 25, hold it in a trust for them. We can do that all within a will. It doesn't need to be complicated, see? And hold it in trust with them, with my sister-in-law perhaps being the trustee, who can make decisions for them and spend that money outside of court supervision. Then I turn around and I list the life insurance policy as the beneficiary. So the beneficiary of the life insurance policy, instead of it being the kids, as the possible trust there for them. That if they are going to be under that age of 25 or 21, wherever you might think they might be of a smarter age than 18, that the money can be directed there. Listen, I can't believe how quickly the time has flown by. I know that this is going to stay up there. So if you have questions about this stuff, go ahead and still put them in the comments. We can get some more questions in there. Don't put any confidential information in there. Just ask a general question. I'd be glad to answer it for you. And we can certainly do this again. If you like it, let me know. Put a like or a share button there for me. That would be great. And I'll take that as feedback that you really like this, and I could find a way to plug this in, maybe not just on a last minute thing. COVID is making us rethink how we get out and reach out to people. So much of this stuff is people just don't know their options. And so we really want to get out to people. So we haven't been able to do so much of our in-person seminars like we've done in the past over here in Riverhead. Haven't been able to do as many speaking engagements to get this information out on either fork. So if we can help in any way, put a question, put a share in there. I would be glad to do this again for you. Listen, have a great afternoon. And I hope to see all of you soon. I hope that you are all doing really well. Thanks.